Commission on Human Rights has written to the Director of Public Prosecutions seeking to have some 20 aspirants barred from the August polls. Joining me now is the Vice Chair of the state-run rights watchdog, George Morara. Thank you so much for joining us. So we understand that you've written to the DPP concerning the following politicians: David Gikaria, Okoth Obado, Tyrus Ngahu, Otiende Amolo, Neto Adola, and Hussein Dabaso. Largely, your report centers around the irregularities and violence that we saw during the party primaries. What is the nature of evidence that the Commission has against these six?
Let me start by saying that listening to those names is clearly tantamount to what I would call putting the cart before the horse. Because as a commission, you're right, we've conducted our monitoring in about 33 counties. We found blatant cases of electoral malpractices, and as you rightly say, we are taking the next steps, which includes writing to the ODPP so that action can be taken against those ones who identified.
Are you saying these are not some of the politicians who will be you've written to DPP about?
At this point in time, actually, the principles of natural justice require that I don't go on air to discuss whether these are the six or not, because they have to be given an opportunity, whoever they are, from our own internal reports to identify, to respond to the issues that we found against them.
All right, so you're not denying that it's these ones. Having said that, what is the nature of the evidence that the Commission has? Do you have photographs, videographic evidence? What is it?
Well, I don't want to confirm that it's those ones, but I want to say that the way we conducted our research out there, our monitors went out there, they were able to capture certain information, certain pieces of evidence through recording, through camera, and this is the information that we're going to use. And I want the viewers to know that we're not only relying on the ODPP, but we also want the task force that was established, the so-called Chapter 6 task force that's led by the Attorney General, to actually probe all the men and women who have been identified by our report for action as per the laws of this country. So
you're saying you actually have them on tape committing these crimes?
Well, we have actually used various forms of securing the information, including capturing some of them on tape.
All right. Why did you not go to IEBC directly with these allegations if you have it even in video format?
Well, I think, like I said, there are many stages. One is the Director of Public Prosecutions to pursue the criminal course of it. But then also, like I said, IEBC is part of that Chapter 6 working group, and this information will be submitted to them. We were very clear today when we were releasing this report that any leader who doesn't meet the requirements of the Leadership and Integrity Chapter should not be allowed to vie. So we hope that the IEBC, actually we're going to push them to take this into account. Furthermore, we've gone to court, because I think there's been a problem on the application of the Leadership and Integrity Chapter. So we've gone to the Supreme Court to seek for an advisory opinion on what is the fit test to use when we're actually vetting leaders. Should it be a criminal test that goes beyond reasonable doubt, or an ethical test that actually looks at the balance of probabilities and therefore bars a certain leader from vying just because they have violated certain ethical standards of society.
And that would, to some extent, speak to the concerns that lawyers have already raised regarding your action, which is the fact that, you know, the same court ruling which allowed the president, well, then they were candidates, Uhuru Kenyatta and William Ruto, to run for office because they had not been found guilty of, you know, crimes against humanity. That may be the same argument that defense lawyers would be using, but to the extent that you're covering that by going to the Supreme Court for an advisory opinion, there is still then the concern that this going to court, it would take quite a significant amount of time, and that we might even end up at the elections before you have these matters conclusively heard and determined.
Well, what we want to say is that already we're in the Supreme Court, and I like the fact that you mentioned maybe previously the courts have also ruled on this matter. But what we find is that the lower courts have been actually given very conflicting rulings on this matter. When it comes to elective positions, the standard seems to be a lower standard that actually calls for somebody to be found guilty beyond a reasonable doubt. But when it comes to appointed positions, and we've seen this, for example, in the case of Waitito, who lost his position, then the standard is a little bit lower. So we want a harmonized interpretation of this chapter and what it exactly means. Now, whether this happens after August, it doesn't mean that the further action cannot be taken against the men and women who are found not to have met this standard, even when they're in office, because again, we can pursue these cases beyond the August 8th 2017 elections.
Should the DPP not be prepared to go to court with the evidence that you forwarded, or the working group find that it is not enough, is K and CHR ready to go to court directly to prosecute this case?
We've done our work. We don't work in isolation. Actually, for your information, Anne, we also sit in the ODPP, and we've done our work, so we hope that the other agencies will actually take up from where the information we've given them, and that they'll be able then to use the law to ensure that we have an election that is actually in line with the laws of the land.
George Morara, Vice Chair, Kenya National Commission on Human Rights, thank you
Thank you
for your time, and we're taking